what we're really dealing with is, I mean, if ethically a doctor wants to treat the mother and child as two patients, they're not going to have a problem with these laws. It's really a political or ideological opposition to the laws themselves, but they're not difficult to understand.
Welcome back, and this is part two of a two-part conversation with Clarke Forsythe, Senior Counsel at Americans United for Life, and also author of an amazing book called Abuse of Discretion, the Inside Story of Roe v. Wade. In part two of our conversation, we are going to be now diving into what does our legal landscape look like after the Dobbs decision that overturned the really egregious Roe v. Wade decision, and how does it look maybe in some ways similar to the pre-Roe landscape, but also how is it different? And we're going to discuss some of the issues that we're dealing with as a movement now since the Dobbs decision. So Clarke, welcome back.
Thanks, Dr. Francis. Always good to be with you.
Thanks so much. So again, in the first half of this conversation, we talked a little bit about what pre-Roe pro-life laws were like. You said there were 30 states prior to the Roe decision that had essentially outlawed abortion, obviously allowing for interventions when a woman's life was in danger. So what are some similarities and differences that we see between pro-life laws that are on the books today and laws that were in place? Are they essentially very similar, or do we have any crucial legal differences there?
Well, basically, we're talking about 16 to 17 states that have early gestational limits or prohibit abortion throughout pregnancy and have a life of the mother exception. And that's because the 50 years under Roe versus Wade was a time of great unsettling and a lot of ferment. And some states repealed their pre-Roe laws, and the number of early gestational limits were reduced. And then with the Roe decision, with the Dobbs decision, the court immediately sent the issue back to the states, the people and their elected representatives in the language of the Supreme Court. And as you remember, on June 24th, 2022, there were a number of states, attorney generals and governors, who announced they were ready to enforce their laws immediately. Mm-hmm. The Dobbs decision was excellently written. It was very clear, and cases in the courts with challenges to state laws were thrown out. The cases were thrown out, and basically state officials could enforce the laws in all 50 states. Mm-hmm. But there were only, at the time, there were maybe 19 or 20 states that had early gestational limits. Some of those, as you know, were eliminated by state ballot initiatives. So today, we're talking about 16 or 17 states which prohibit abortion except to preserve the life of the mother. And we could call those medically necessary abortions or abortions to save the life of the mother. But those are the 16, 17 states we're talking about. And those laws may have been tweaked somewhat since the pre-Roe years, but they pretty much deal with saving the life of the mother or preserving the life of the mother, and what that means, as a legal matter.
Yeah, absolutely. Well, and I live and practice here in Indiana, and we were the first state after the Dobbs decision to have a special session of our state legislature to debate an abortion law, and thankfully ended up passing a law that prohibits most abortions. Of course, every state in the country has a provision for protecting the life of the mother, as you said, and providing for interventions to do that, what APLOG would call a maternal fetal separation, where we need to separate mom and baby to save the mother. Indiana has a few exceptions as well for fetal anomalies and for rape or incest, but thankfully we have seen most of our abortions go away. There were other states that had their pre-Roe laws still in effect. And I know there's been a lot of discussion around those, and many people, I think, assuming that there's no way that that would be safe to leave a pre-Roe law on the books because it wouldn't allow for doctors to intervene when we need to save a woman's life in the case, say, of ectopic pregnancy or a life-threatening condition like preeclampsia or infection. But of course, doctors were intervening for those things early on or before Roe, legally, and not being prosecuted. Is that right?
Absolutely. There have been no prosecutions since the Dobbs decision. And as you said, you know, every state, when the mother, in those rare conditions, when the mother's life is endangered, every state allows an abortion, whether it's defined as that by law or termination, or as you said, a maternal fetal separation. And these laws have been debated since the Dobbs decision, and it's been clarified what they do. There's been a lot of discussion with legislators. There's been a lot of discussion between doctors and legislators and governors, and this has been thoroughly explored. And these laws are clear. They're not vague. They're not ambiguous. What we're really dealing with is, I mean, if ethically a doctor wants to treat the mother and child as two patients, they're not going to have a problem with these laws. It's really a political or ideological opposition to the laws themselves, but they're not difficult to understand. I mean, realistically, if for 50 years under the Roe versus Wade decision and its negative impact on medicine and culture, doctors never had to obey these laws because they weren't enforceable, then some doctors are going to have to go back and understand what they say and what they do.
Right.
But if a person of average intelligence can look at these laws and understand that, for example, they require an intent to actually take the life of the child, and when there's under factual medical facts that you can articulate and identify, whether it's preeclampsia or something, there's an intent to have a maternal fetal separation without a specific intent to kill the child.
Right.
And so these laws are clear and not vague, and they're not ambiguous. I think it's more appropriate to call these situations medical necessity rather than medical emergency, the term that ACOG may use, because it's not necessary that the doctor have an emergency.
Right.
There are medical conditions, as you know, that require a maternal fetal separation, but the doctor, contrary to the claims, does not have to wait until death is imminent, does not have to wait until there's an emergency. The doctors can act, and they can act based not by some kind of one size fits all standard for every state, but they can be attentive to each patient's condition and each the symptoms that each mother has, and each the conditions that each mother has.
Yeah.
And it's important to understand that virtually all these laws rely upon reasonable medical judgment.
Mm-hmm.
And that means that the doctors are not going to be second guessed. It's a standard that allows the doctor to make a judgment, a reasonable medical judgment based on the mother's conditions before them.
Absolutely. And contrary to the fear mongering that's being done by abortion ideologues, including those at ACOG, the justices in the Dobbs decision, but then also state lawmakers across the country who have enacted these laws, did not just make up this concept of reasonable medical judgment out of nowhere. It didn't suddenly appear in the year 2022 after the Dobbs decision. Even though I have heard uh, ACOG reference and other pro-abortion advocates reference that, how on earth are doctors supposed to know what this means? This is legal precedent that we use in many aspects of medicine. It is used in medical malpractice law. It's used in disability law, that doctors use their reasonable medical judgment to determine that a patient has a disability, that they should qualify for disability. So if this is something that's so confusing for physicians, then there are multiple areas within medicine that it should be impacting. Is there ever been a time where reasonable medical outside of this that you're aware of, that reasonable medical judgment has been questioned really as a legal precedent?
No, and even within the context of abortion, there's a recent article that was just published in the Notre Dame Journal of Law, Ethics, and Public Policy this past June by Quinlan and Linton. I urge every lawyer and doctor to read it. It's really quite an exhaustive focus on so-called medically necessary abortions, and it looks intently at the law and the medicine, and it documents that we're talking about before Roe, there were two prosecutions. One goes back as far as 100 years.
Wow.
And in these two prosecutions, they were thrown out on appeal. So you're talking about very few, two prosecutions before Roe versus Wade, and there haven't been any prosecutions since Dobbs in 3 years since Dobbs. And it's because of the clarity of these laws and because of the standards they use, like essentially reasonable medical judgment.
Yeah, absolutely. Well, and this is an issue that we address. Applog put out a continuing medical education video on this issue with a maternal fetal medicine specialist and an attorney, talking about how doctors can continue to provide the care that they need to their patients. And one of the things we talk about in that is the importance of documentation. Of course, we know as physicians, and as an attorney, how important documentation is. We learned during our training, if you don't document it, it didn't happen. So documentation is very important, but it's also important in this situation. If you document as a physician, this is my thought process. Here's what I see when I evaluate this patient. Here's what I determine the danger to her is. And this is why we think the best course of action is to end her pregnancy right now. If you document that, you are protecting yourself, you're protecting your patient. And as you said, there hasn't been a single prosecution, even though we know from states that report their abortion numbers, we know that terminations of pregnancy for the purpose of saving the life of the mother are happening in states like Texas and states, my home state of Indiana, and yet not a single physician has been prosecuted. And so I think part of what we need to do is just sort of calm down the rhetoric, and for people to understand we can still do our jobs. I've told this to many people, but my hospital system, I was so thankful for them when Indiana's law went into effect. The actual guidance that was given to us was nothing changes. We continue to do everything how we always have, because that's how our hospital has always practiced. We had one additional piece of paperwork that had to be done in certain cases. That was it. That was the only change that happened because of our law. And that was such clear guidance to every physician, every nurse in our hospital system. And yet we know, unfortunately, that there are hospital systems out there that are not giving that kind of clear guidance to their physicians. And that's what's causing the problem. It's not the laws themselves.
The laws, it's a lack of education or a willingness by doctors to read the law and become educated, frankly. And I'm so glad to know that Applog video has been produced and is being distributed. I foresee that kind of education is going to have to continue for several years until doctors are re-educated about things they didn't have to deal with or didn't have to know during the Roe years.
Yeah.
But as you know, also, the opinion in the Dobbs decision was leaked early May of 2022. And with that leaking of the opinion and the expectation that the court might overturn Roe, state officials started even then to educate about the laws on the books And when the Roe decision, the Dobbs decision came down on June 24th, 2022, again, governors and state attorney general and state health officials went out and started educating about this is what our law says, and this is what it means, and this is what it does. So that education is going to have to continue, and until we tamp down the dissenting voices, that the political voices that express confusion when there isn't confusion, who make these claims of vagueness when there isn't vagueness, or ambiguity when there isn't ambiguity. And I just foresee that the type of education that APLOG is doing is going to have to continue on as wide a basis as possible for at least several years to come.
Absolutely. Well, and thankfully, we've seen a few states, I think, do a really good job of this. Florida had their Department of Health issue very clear guidance after their heartbeat law went into effect to their physicians to ensure that physicians would know that they could act in an expeditious manner when a woman was facing a potentially life-threatening emergency. We've seen states like South Dakota, North Dakota, Texas pass laws actually requiring medical education for physicians on this particular issue, on their abortion law. The Texas law was the first one I've ever seen that required CLE, so continuing legal education for attorneys in the state, which I thought was great, because one of the things we've heard from members and that they have heard from their colleagues is that sometimes it's the hospital attorneys that are actually causing a lot of the confusion. And maybe because their job as an attorney is to protect the hospital, but it may be that they also are just caught up in the rhetoric that is being circulated right now. So I thought that was really amazing. I'd love to see this on a national level. Nationally, as physicians, we were mandated, in order to maintain your DEA license, you had to do 8 hours of CME on opioids and substance use disorder. So this is not an unprecedented thing for there to be requirements placed on certain types of continuing medical education. And as you said, it's so, so important that doctors be educated about this so that they understand that they can act without hesitation to save a woman's life, or to prevent, many states even have the language of to prevent permanent physical impairment as well.
Yes.
And so, as you said, it doesn't have to be that the woman is dying on the table in front of you before you can intervene. Of course, our goal is to intervene well before we're in that situation. You probably know or heard the story of Representative Kat Cammack from Florida, who published her story in the Wall Street Journal of going to a hospital in her home state of Florida shortly after their heartbeat law had gone into effect with an ectopic pregnancy. And her doctor told her that they were unsure if they could intervene because of Florida's law. Now, thankfully, Representative Cammack knew her state law well. She knew that it said in very clear language that it in no way applied in the situation of an ectopic pregnancy, which I think every state law that I'm aware of clearly lays that out, that this law does not apply to ectopic pregnancies. And so she was able to advocate for herself. But, what I think of is, what about the woman who doesn't know her state law very well, who only has heard the lies that are out there in the media about that this, pro-life laws are killing women, who then has a doctor who's a little bit confused and is unsure if they can act? What about that woman who can't advocate for herself? This intentional confusion is what's causing harm to women, not the pro-life laws themselves.
Absolutely, and that points out the need for fully informed consent and for continued education coming, as you've said, from states, state officials, state agencies, from local hospitals, and good advice from doctors. I mean, doctors have an obligation to know the law. They have an obligation to obey the law, and doctors all the time have requirements of education. And in the post-Dobbs era, they have an obligation to be informed about what their law does. And as you pointed out, one of the things that these laws do is define what an abortion is under the law. And in many states, an ectopic pregnancy is simply excluded from the definition of abortion.
Yeah.
Another way in which these laws are clear, not vague, not ambiguous.
Absolutely. Absolutely. Well, and as you pointed out, one of the objections that I've heard to pro-life laws is that politicians and lawmakers should stay out of the exam room. Of course, you and I both know that in most situations where a woman is obtaining an abortion, that is not a sacred physician patient relationship. Typically, oftentimes, there's not even a physician involved nowadays. But also, typically, the woman does not know that physician ahead of time. That is not I think, what people think of when they think of a physician patient relationship. But also, even just to say that is completely ridiculous on its face. Medicine is one of the most highly regulated professions that exists. And so we, as you said, we as physicians are used to functioning within not only federal law, but state law as well. And many things within medicine vary widely from state to state as far as do you have to be a mandatory reporter for X, Y, or Z? Are you allowed to do this? What are the regulations that are put as far as health and safety regulations on your office or on your hospital? So these are things that we are used to dealing with as physicians. And so I think sometimes it's just good to remind physicians of that as well, that these laws are not requiring you to do or have any particular knowledge outside of your routine knowledge that you have as you function within the law of your state. So
Yeah, if government has to get out of medicine, then I guess we'll have to repeal Obamacare
that's that's right. That's
and
right. Very
hundreds of other federal and state laws that doctors abide by every day.
absolutely. And we abide by them even when we don't necessarily fully agree with them, too, because those are the laws in our state and we practice within those. So I think that that's important to point out as well. Um,
I would also add that another way to see these state laws, these state abortion laws, is that in addition to um, limiting abortion and allowing maternal fetal separation when the mother's life is in danger, they thereby prevent the unnecessary destruction of the child.
absolutely.
And they are protective of the child and seek to make sure that the child is not unnecessarily destroyed when maternal, as you say, maternal fetal separation can happen without such a specific intent. And that's really the question. You can have a maternal fetal separation without specifically intending to take the life of the child.
Absolutely. The title of this podcast is Caring for Both, because we say all the time that when we're taking care of a pregnant woman, we're caring for two patients at once, and our duty is to both of those patients. And so these laws, these pro-life laws, really are aimed at protecting all citizens of the state, including the preborn citizens there as well, and protecting women from the harms of induced abortion as well, that we certainly know exist. Well, Clarke, thank you so much for this amazing two-part conversation. I know we could go on and on. I definitely would encourage people to check out your book, Abuse of Discretion. Also, some of the articles that we reference in this will be linked in the show notes as well. Encourage you to take advantage of those resources. As we wrap up, Clarke, can you tell us first what are some projects that AUL is working on right now? And then where can our listeners and viewers go to learn more about AUL's work?
Well, AUL.org is a rich treasury of data on the laws that protect life in this country and on our work in the courts and the legislatures and the media. They tell the story of the work that we're doing in the courts and legislatures across the country. And we have been emphasizing the protection of pregnancy resource centers since the Dobbs decision, because the health and protection and growth and strengthening of pregnancy resource centers are so important in the months and years ahead. And so we've been just privileged to be involved in that work, as well as working in states to pass good laws, clear laws, and laws that will protect life, not only in the abortion arena, but also regarding preventing assisted suicide and protecting human life and dignity throughout the law.
Absolutely. Well, and I would highly encourage people to utilize AUL's website. I do quite frequently. They've got a great interactive map if you want to see sort of the legal landscape of pro-life laws across the country. And as you said, Clarke, doing amazing work in supporting and defending pregnancy centers who are doing such crucial work in this uncertain time where I think a lot of women feel very scared and need support. But they are also under attack by many pro-abortion states. And so the work that AUL is doing to support them and also advocate for support for pregnant women, both during pregnancy and beyond, is so, so important. So Clarke, thank you. Please convey our thanks to the entire team at AUL as well for the work that you all are doing.
Thank you, Dr. Francis, and thanks to Eplog for all your great work.
Absolutely. And thank you so much to our listeners and our viewers for joining us today. If you liked this episode, please be sure to give us a like and a subscribe on YouTube. Or if you're listening on a podcast app, please be sure to give us a 5-star review so more people can access this important information that we cover. We're so thankful for all of you who are our members and our supporters. If you'd like to continue to help us to clarify facts in the midst of confusion, please join us as a supporter as well. We can only do what we do with your membership dues and with support of our faithful donors. If you're interested in joining that team, you can go to applog.org/donate. Thank you again so much, and we will see you on our next episode.